So I have been an IP teacher and scholar for 20 years but before that I was a lawyer, and before that I was a PhD student with my work comparative literature. So I think a lot about the intersection of law and other things all the time. That's what I do. And so this project is the second volume of an ever-extending work on the role of intellectual property in creative and innovative people and communities. And so the book came out last year, and I think I gave a talk on a chapter of the book 2 years ago here, just on the second chapter, which is on equality. So what I decided to do when I embarrassingly found out that I was spoken about this project before, I decided to give an overview of the book rather than a deep dive on one chapter. And that one chapter is actually a very doctrinal chapter about equality law and law. And so the conversation in that at that time was really about the way we conceive of equality in constitutional sphere and elsewhere. This is going to be much more of a survey, and I hope entertaining, as much as it may be provocative. So the book focuses on the changing nature of intellectual property in the digital age, that is how is IP evolving in our digital literature. And the title, Against Progress, takes its origins from, as you might imagine, the Progress Clause of the Constitution. Power to grant limited exclusive rights to authors and inventors in order to promote the progress of science and arts. So like so many other things, like I was just saying, this project is really a continuation of my previous book called The Eureka Myth, that was published in 2018. In that, that was a qualitative and critical work only. And I did a series of interviews over about 5 to 6 years to understand from the creators and innovators themselves how IP works or doesn't work for them in their everyday lives. So the everyday life of law for artists and scientists. And in that book, I learned through the interviews and coding the data that IP law, at least in the United States, from a utilitarian perspective, is really very deeply misaligned with the experiences of creators and innovators doing their work every day. And that misalignment is very common in the context. We have perfect alignment is probably intolerable, but that misalignment was, I think, causing a lot of problems. And so one of the things I started asking myself after I identified all the different ways it was misaligned, I started thinking, like, what is the progress that IP is supposed to be aiming for? And can we redefine it? Like, is it an open question, actually? I'm also a constitutional law professor, I should say. I've been teaching constitutional law since 2004. Common law changes a lot all the time. And so, like, why can't progress mean something different in 2024 than it did in 1789, for example? So that is one of the questions that I started asking. And I wanted to, the question really was the net, how am I going to get? So, the justification, of course, for reading into the Constitutional Progress Clause, something more and something varied, comes from the Supreme Court itself. This is Marbury. The McCulloch versus Maryland. Sorry, McCulloch versus Maryland. A less onerous case in Marbury. That the idea that the Constitution was intended to endure and to adapt to the crises of all ages and of human affairs. And so I thought, okay, if I teach this every year, that the Constitution adapts, that it's a living Constitution, what does the Progress Clause mean in 1789? Do we care? And if you start looking into that history, actually, the history of the Progress Clause is very thin. There's actually not a lot there. You can't really tell very much from the original papers. And the legal history of intellectual property since 1789, the date of the clause, actually demonstrates how intellectual property law has adapted to new socio-political and cultural shifts, that it's responding to technology and new production modes, assisting the growth of certain industries and not others, plays favorites. And that powerful stakeholders often were drafting the legislation around IP. 4 centuries. So the progress of IP could possibly mean, you know, a democratic form of progress, situational, historically considered. And this project asks about our situation, like what is IP for today in our digital age? And I think one of the ways I was conceptualizing this project is if progress means something different today, or that was my hypothesis anyway, what did it mean maybe in the 20th century, not maybe or in the 19th century? And so one of the arguments I make in the book is that for most of the 20th century, progress actually just meant more. It was accumulation, more patents, more copyrights, even more trademarks. Trademarks, I know, for the geeks in the room are not technically under the Progress Clause, they're under the Commerce Clause, but we do think about them as assisting commerce on the flow of goods, that more distinction and more competition is better. And so we think about more trademarks actually being better as well. So the progress is more sort of, there's a flourishing in the 20th century with this idea of broadening collecting IP. And we see that, we actually see this idea of progress equals more IP. Now, it doesn't necessarily mean more creative work, more innovative work. It really does mean more IP in a lot of different ways. So, for example, copyright originally conceived in 1790 only covered mass charting books. It had very narrow subject matter. And the idea behind maps, charts, and books, informational goods, right, not highly creative, informational goods, was that it was going to promote making of more maps, which were going to be sold for their information. So this is my hometown of Boston. We get lots of different maps. They show lots of different things. They improve on one another. And so the idea that IP or copyright was incentivizing map making when copying those more onerous for people to buy the maps instead of copy them when they would copy maps. Copyright actually expanded beyond maps, charts, and books to art reproductions, technical drawings like manuals, translations, to photographs once photography was invented, to film once film was invented, to advertising once the advertising industry experienced a huge boom in the 1920s and 30s to manufacturing labels, and finally to sound recordings. So the idea here is that the scope of copyright was broadening tremendously, and therefore more things copyright. And then in 1903, to the turn of the century, the Supreme Court issued a decision called Weinstein against Donaldson, in which it debated whether the circus posters or the advertising for the circus could be copyrighted, whether the original protected materials, whether it was art, essentially, although whether art was under the original Progress Clause in the debate. And what the court said in that case is that we as judges can't judge art. This is creative. It has a spark of creativity, and it inaugurated this aesthetic non-discrimination. So all of you are thinking about what I said at the beginning about equality, non-discrimination, and copyright go hand in hand. We don't make this unlawful distinctions in copyright between art and but what this standard did in 1903, at the beginning of what we call the mid-20th century, is that it inaugurated this non-discrimination principle that promoted copyright. Anything could be copyrighted that has spark of originality, and what we get now is anything is copyrighted. The Yelp review, the shampoo bottle, the photo that you put up on Instagram. And whereas copyright lasted in 1790 for only 14 years, which registration, copyright, and put notice on it. Now, after the amendments in 1978 fixed, and then 1998, it lasts for 70 years after your death. So your notes on your computers, your Yelp review, 70 years beyond your death, you have exclusive control over them. So, yeah, what kind of progress is that? In patent law, we saw a similar expansion. So at the founding, the kind of patents that were being promoted and interested were agricultural tools. So we thought about candle making, fertilizer, flour mill, printing types. These are the things signature inventions of the early US economy. The Industrial Revolution gave way to new machines as inventions. And so it was always still covering machines until pretty much 1980, when the Supreme Court again issued a stunning decision that said anything under the sun that is made by man and is inventive that is not obviously useful, the novel, can be protected. Since the 1980s, we have patentable subject matter that has broadened, not that copyright has broadened to include business methods, improvement and parts, and genetically modified microorganisms. So parts of things rather than whole machines now get protected, and business methods, states with bank controversy and software patents. And living things, but living things like viruses or genetically modified tools that were made by humans. And so what this has birthed actually is rise to new social movements around food justice, agricultural equity, and access to healthcare, because more and more is locked down under patents. So many more copyrights, many more patents. Trademarks, you can tell the same type of story. I start becoming a little repetitive, but repetition is important here. Trademarks have expanded over time. We tend to think about trademarks as signs or words that our devices signal the source of the good or service. But like with copyright and patents, over time, the trademark scope has broadened. So we get trademarks in the look and the feel of the goods as well. Trade dress, so the shape of the Weber grill, just the blue of the Tiffany box, the shape of the thermostat, all protected trademarks. We even get trademarks in smell. Plato's smell is trademark. We have trademark in the lion floor for MGM, for example. The trademark statute was amended in the middle of the 20th century to basically say that anything can be a trademark, just like live things that almost anything can be copyright, without regard to the nature of the work. And in the end of the 20th century, the Supreme Court issued quite a famous decision called Taco Cabana versus Ducatos, in which it said the festive eating atmosphere of the restaurant was protected from trade. There are very few limitations on trade dress trademark today. So as a narrative scholar and someone who's based in the humanities before I was a lawyer, I'm thinking about stories. Like, what kind of story is this? This is a story whose plot is about growth and accumulation. The story that begins optimistically, focusing on economic investment, opportunity, new nationhood, driven by the idea of a free market, accumulate lots of IP, which will be fairly and efficiently distributed. That was the theory. Born on the eve of the roaring 1920s, that is when a lot of this started happening. Hit its growth first in the 1950s and 70s, when we inaugurated 3 new IP laws right after World War II. Copyright took the longest, but it's the most efficient. And in the backdrop is this growth of mid-century companies. Think about manufacturing, scientific discovery, entertainment industry, advertising, all the great companies. They're still the great companies of the 20th century, now being challenged in the 21st. And it disappears. The story here is this like exuberant race. I mean, I'm telling the story. You can tell me if you agree with it. But that maximize the benefits of what is perceived to be a consumerist market economy, which amplifies values like choice. Trademark is about choice. Individuality, copyright is about individuality and originality. Opportunity and innovation, and abundance. Just let's collect a lot of it. And it's epitomized in many ways by places like Times Square, where all of the choice, abundance, individuality, and opportunity. And by the 1980s, with the arrival of the personal computer, I think it's fair to say that many people thought intellectual property and statutes that regulate it was doing exactly what we thought they were supposed to do, promoting progress as capital growth and bringing the wealth from many, many companies and from individuals. The internet revolution, the internet revolution is disrupted that concept. That the transformation of civil society in the digital age through the internet is actually an existential threat to intellectual property regulation that aims by their very nature to control the making, the innovating, and distribution of new things without authorization from the ones that are wanted. IP laws exclusive rights to control making and using is an exception to the internet's mantra of freedom and distribution. And yet the internet and creativity and innovation as enabled, which is defined by generativity, I mean, it's literally defined by generativity and virality and copying, moving around roadblocks that IP actually find regularly to create and digital laws trying to create, is the way internet users, all of us, like you can imagine not using the internet on an hourly basis. That's how we work. So lest we think that though, so I'm not an exceptionalist. I don't think the internet is all that unusual historically conceived in a specific way, as a copy machine, okay? Because we had those things, we dated the copy machine, the literal photocopy machine. Those were sued for a long time, whether the machine was liable or the user was liable. We had fights about the VCR and the tape recorder. I'm old enough to have sat by my radio when I was a teenager to try to record my favorite songs on Casey Kasem's Top 40. These were all threats to intellectual property at the time, to copyright in particular anyway. They were almost due out of existence until we got a Supreme Court decision called Silbey versus Universal, which said that by 5-4 decisions, the VCR was allowed to continue to have a record button. What did Universal Pictures want? They wanted a VCR with just a play button, no record button. It was allowed to have that record button, and then we were off and running. Okay. The idea, though, was that all these machines were going to basically make books and movies disappear. Right? That was the idea. That is the kind of thing that we hear today. So as with the copy machine, though, I mean, what is the difference between here? So with the copy machine, and then what happens? We get many more innovations. Now, Blockbuster is now out of business. Netflix looks very different than that red envelope that it used to look like. I could have put Stability AI or DALL-E up there as well. Like more and more technology that's just reproducing, copying, and making new things. So we can't live without the internet. Really, I don't think we want to. And yet, what do we do with the right-click copy and send? Right? The internet doesn't stop us from committing copyright infringement every single day, which we have to do today. When we repair our phone or our car or our coffee maker, even many of us committing patent infringement, whether we like it or not. That's the right to repair movement that is spreading across the United States. No one's stopping. We are doing it anyway. We are becoming pirates and vigilantes because these laws are so misaligned. And the kind of spooks that go on online all the time, the memes or whatever, trademark infringement, what trademark owners think is infringement anyway, it's constantly being litigated in law because the trademark owners feel their dignity is being harmed by jokes like this. All of this behavior is inevitable in the digital age. I would call it a kind of progress. I actually think this is moving forward in a kind of semiotic way. But it also makes us into pirates. Like we're all breaking laws on a regular basis. The question is, what kind of IP laws are there if we're regularly moving around them or fighting against them? And so it makes me think, it's made me think for a long time, the uncomfortable status of kind of basically violating copyright law today, is that IP is historically justified, have to change in the 21st century for our values and our interests to align. And so it just made me think, like, this seems like a very basic question, but like, what is IP for? Like, what is it doing today? What is it for? And do we have the power to think hard about whether it should be serving different interests or select interests? So why do I think that it's right for change? So I've already told you that I think the progress clause is an open, is a blank check for the Congress. Or ambiguous. Some things are happening, like for example, the Supreme Court is taking IP cases at more than a double time than it has in decades past. Starting about 1995, the Supreme Court has gotten itself busy opining about IP law. Now, I don't like when it opines about almost anything, but this is an opportunity to shape how intellectual property is conceived. I think the Supreme Court is a national narrator of constitutional, largely constitutional, as well as federal, national values. And so when it's getting involved in IP, none of those people are IP. Justice Sotomayor was, had some IP cases in her when she was a district court judge or a appeals court judge. So she has, I think, the most experience, but nobody knows. They don't know about IP. I mean, they weren't IP litigators like I was. They were definitely not in-house and so pictures, for example. But they are deciding what these statutes mean, and they're infusing their decisions with certain kinds of stories. And that's part of what the book talks about in the first chapter, is about the Supreme Court's discourse around IP and how that's shaping the debates. I'm happy to talk a little bit more about that. The second thing was the Supreme Court's taking cases at rapid pace. The second thing that's happening, and this may feel, I don't know how foreign this is to you, but when I went to law school in the 1990s, the only IP professor at the University of Michigan, there was only one, and she taught IP only part of the time. Okay, IP was not a course that was taught in the 1990s with full faculty. We had a lot of adjunct faculty. It was like admiralty law, right? It was certain, I don't know, like maybe bankruptcy law, the bankruptcy law a little more hot today. It was a niche practice and a niche class. And we were geeks in the corners. Like, who wanted to study patent law in 1990? Or like, God, we were trade secret law or something like that. But today, you are not a law school, like a legitimate law school teaching law students what they need to know. If you don't have like 2 or 3 IP faculty on your faculty, and these centers are all over the place. That is, IP has become the center of study in law schools, and I should say, as a parent of teenagers, they learn about it in school, and business schools as well. So it's a mainstreaming of intellectual property law from an obscure corner of law to a public consciousness that I think is also changing what IP is and what it's for. We also see it in our headlines. I mean, you have to do a time-based analysis of this. If you look at headlines, the headlines in the New York Times, that are watching the post, I change them all the time. The newspapers are writing front page above the fold stories about IP. I mean, I get calls from reporters so much, and it's like, I'm just like just my IP professor, and they want to know about Andy Warhol, like this is the Reuter wants to know about Andy Warhol. These are new things. This is a new way of what's important in contemporary society. Oh, and by the way, like I collect all the TV shows and the movies with IP references, exponential over the past decade. Patent views are on The Good Wife. Silicon Valley is all about patent trolls. It's part of our popular practice. So this is what I call in the book a kind of domestication of intellectual property law. It affects the popular conceptions of who creates, what innovation is for, and I think new stories are proliferating, debating intellectual property's justifiable scope. So we're in 20th century, I think we saw a democratization of intellectual property, more of it, more people could access it, that is, more people could be inventors and copyright holders and trademark owners, more IP and more markets. In the 21st century, I think we're seeing a domestication. And that domestication is not about markets and money as much as the 20th century. I think the 20th century story was about war. I think the 21st century is doubling down on certain fundamental values that is part of constitutional discourse, as well as fundamental human rights discourse in the United States, as well as around the world. And these are the values that I think I can explain a lot of the weird IP cases that people talk about. That like, that's not an IP case. I'm like, it's an IP case if you think IP means something different today than it did 25 years ago. And so these are each chapters in the book. Okay. All right. So, how do I know this? Like, what's my data? I did over 100 interviews, so I doubled the amount of interviews from the Eureka Myth. So I piled on. I did a case study on photographers. That's also a chapter on the book to figure out. And then I don't know if anyone here thinks about or works in the digital humanities, but I created a corpus of all the IP cases from the Supreme Court only that was decided from 1980 to 2020. And I worked with a computer programmer because I failed Python, and to create digital humanities approach, which is called topic model. Figure out how do we understand this big data set? What are the themes in them that a human can't see? So I can happy to talk about those methods in Q&A, but just so you know, like I'm going to tell you what I found, but I was working within specific empirical and humanities-based approaches to make my argument that these values are animating intellectual property law today. So first I'll tell you about the cases, so tell you about how these cases are about these values with 3 stories, and then I'll share some interview data and then I'll. So you guys know this case, Naruto. So she's a macaque monkey from Indonesia, and she's famous because she allegedly took this photo of herself. You know, it's the famous monkey selfie case. But David Slater, who I became friendly with, you know, he says, I took this photo. You know, I'm the one. I'm the nature photographer. I set up the camera. I encouraged the monkeys to play with the equipment because he was in the jungle for a very long time and he couldn't get a good photo. And so he innovated and tried to get them to basically start playing with the monkeys. And he eventually lured them to play with the camera. And so they ended up taking pictures. And they took many pictures. That's extraordinary, what he calls outtakes. And he published some of them that became quite famous. He licensed them. He started making quite a bit of money. Photographers don't actually make a lot of money, but he started making quite a bit of money. And then he got sued by the Protection of Ethical Treatment of Animals, arguing that he was using a photo that he didn't own. He was committing copyright. So super funny. Like I love teaching this case. This is wonderful. Except just like when you think about how much money this lawsuit actually cost the parties, it went all the way to a federal appeals court, required significant time and money on both sides to convince a court, and eventually the Copyright Office got involved that only humans can be authors. That was the story in the United States. It's not true in England, that he has copyright in England, but in the United States, he is no one owns this. No one in the public domain. Now, I don't know why it's so obvious that only humans can be authors. Like that was the story that came out of this case. PETA brought this suit to assert the dignity of the animal in the way authorship provides, an expression of will in the world. Not that monkeys are humans and that they should have copyright, but that they should have some basic rights that humans have, some of them. And so, you know, children can be authors, but they are not full citizens the way adults are. Corporations can be authors, and they don't have a body, let alone a monkey's body. So capacity and a human body are not necessary prerequisites only in copyright. We are debating today whether AI machines can be copyright authors. You know, so far, not yet, but that is actively being litigated. And what it means to be an author, human author or an author at all, is the debate. And so these debates, I think, are really not about copyright. They're not about copyright. They're really about what it means to have equal access, equal treatment, dignity, not only under copyright law, but generally, and especially today, when the planet's natural resources, that's what the monkey pictures were about, right? When natural resources are growing scarce, and when empathy, cooperation, and mutuality is necessary to survive. What equality might mean today is that equal opportunity to thrive in a planet that's under profound stress. That's what Black PETA brought that lawsuit. But copyright was the train on which it was fought. Okay. Next page about privacy. So this is Cindy Lee Garcia. She auditioned for a movie and performed 5 seconds in a movie. She got paid $500, and then she left. She's told the film was called Desert Warriors. Months later, the film, which she thought she was in, was posted online. Her voice was dubbed over, but her face was there. And the movie had changed, not to the story she thought it was, but it was an anti-Muslim movie, hateful screed against Islam. And she started getting death threats because her face was there and people could identify her. She asked Google to take it down. It was viewed millions of times. She actually had to hire personal security on her own time. And when Google, YouTube said no, because she's not the copyright the filmmaker was, and that's true. An actor's performance in a film does not create an independent copyright. The filmmaker was the author, is the author of the whole film, not the actors, not the lighting designers, not the set designers. The video can only come offline if the author asks for it to come offline, or there's copyright infringement, which there was no allegation of that. The filmmaker was outside the jurisdiction of the United States. And this case went up to the federal appeals court. Because the equities were so concerning, Suzuki wrote the liberation the first time and got overruled the second time. By the end of the day, the answer was it wasn't coming offline. Google prevailed. Google prevailed because she's not the copyright owner, and they stuck by their copyright policies. So I don't actually think this is a case about copyright. I'm sure you're all thinking of a million reasons why this is not. This is a case about fraud and misrepresentation and exacerbation of privacy by certain platforms and their policies, whether it's YouTube or formerly known as Twitter or Google or Facebook or Amazon, policies that prioritize the story from the 20th century, that is efficiency and growth over other values. So IP and privacy are often at odds. That's because IP aims to disseminate stuff, and privacy aims for seclusion and control over identity and life choices. And so there are some old cases about copyright and privacy. James Joyce and his letters, Willa Cather and her letters. These are all about undisseminated works, papers, effects, private thoughts. All of these should be, that's the Fourth Amendment, people, right? And yes, we can protect the stuff that is in our private spaces, our private papers that were left undisseminated. And in fact, for that reason, these cases often prevail. Undisseminated work, privacy and copyright align. But when the work has already been disseminated, they do not. And the question is what to do with that. So here's a case, Hill versus Public Advocates. So Hill versus Public Advocates is a case about a photographer who made this engagement photo, couple's engagement, and put it on her website with their permission. It's an then an anti-marriage equality campaign, a political organization, scraped the photo from her website and used the photo for their campaign literature criticizing the marriage. So the question is that copyright infringement? How should that case come out? Using someone else's published work to criticize its message is usually permitted under U.S. copyright fair use. That's free speech under the First Amendment that copyright law is supposed to embody. But when the couple and the photographer sued, which is totally understandable, alleging copyright infringement, they were really alleging the copyright case is a hard case. What they're really alleging is an invasion of their privacy, their right to control their identity to the public, representation of themselves, and the defense of marriage equality. And as framed that way, even through a copyright case, courts started listening. And this case got so far to trial that defendants actually settled and took down the photo from their campaign website. And now I'm sympathetic to this couple, very sympathetic, and to the photographer, but this is definitely a flow of free speech. This is not the usual copyright case in which in the US anyway, in which we worry about market substitution and lost revenue. That's the 20th century. Like, this is the case about misappropriation of someone's identity, which is squarely a privacy concern, not typically a copyright concern until we get to the 21st century. All right, last case before we get to the interviews and then questions. Farmer Bowman. So Farmer Bowman, farmer in Indiana, at the time of the lawsuit, he was 83, and he grew soybean seeds, and he bought his seeds from Monsanto, great seed giant. Monsanto has a patent on its seed that's called Roundup Ready. So when you plant the seed and you put the Roundup fertilizer on it, your soybeans are like very disease-free. It's super magical. He loved the seeds. He loved the fertilizer. It was really good for a farmer like him. Buying the seeds and planting the seeds came with a license to plant them once and use to sell a soy, not to take the beans, which were also the soy, and replant them as seed, which many farmers do, to prevent the loss in the late harvest, which is very risky. That is, they use the seeds to, instead of buying seeds in the third time around, they plant the seeds. This is this kind of seed saving is something that farmers have been doing for a very long time. Farmer Bowman was sued for that, for saving his seeds. And what happened is the very act of farming was a form of patent infringement. Copying the invention, that is, planting seeds and using them as seeds rather than as soil, even though they're the exact same thing, became a form of patent infringement. Bowman's claim against Monsanto, it's sort of, you have to unpack it because it just feels crazy, right? So Bowman says, I paid you for the seed once already. That's like you bought your phone. I paid you for the phone. I can use the patent and invention on the phone because I bought it and it's mine. It's the benefit of the bargain. All patentees get that bargain. No one else is selling Monsanto seed. Okay, that's not what I'm doing. I'm just using the seed I lawfully purchased. But what Monsanto says is growing seed to plant and not to sell as soy is basically replacing our seeds in the market. You're not going to the marketplace and buying more seeds. You're basically making new seeds and using those if you're duplicating your seeds. And that cuts into our rightful monopoly. So that, that's a debatable patent question. The first sale doctrine does not easily apply. It only applies to distribution, not to reproduction. What do you do about this? What is the answer? The answer is distributive justice. The answer just comes from the framework of distributive justice. The argument is that Monsanto has too much. The rightful reach of the patent monopoly has gone too far. Their sales, 92% of soybean seeds in the United States are grown by Monsanto. And Farmer Bowman is a single farmer, no longer farming anymore, but struggling to make a living. Like, at what level is the answer not that he should be able to save the seeds? A practice which has been going on for centuries, long before we had patents in the mix. He lost this case, and we are still struggling with the repercussions of it. Self-generating technology, computer programs. The idea that this is only a seed case is not tenable. All right. In the last couple minutes, let me share some data with you. The folks I interviewed told similar stories to what I just told you that exist in the cases. But what I want to focus on from the interviews is the fourth category, which is institutional resiliency and inclusivity. And one of the things that I was trying to think about, like what helps you do your work, what helps you be an innovator, what helps you be a creator, what is progress to you? And I couldn't talk to folks who are litigating. I could only read in the cases and the decisions. But when you talk to folks for a long time and you feel like, what is progress in your field or what is progress to you? A lot of the times they talk about what is thwarting your progress. So that's what's going on here. One of the things they see as a problem in intellectual property, and this goes to the misalignment that I was mentioning before, is they talk about it as totally out of proportion. Okay, so that's Farmer Bowman and the Monsanto, the winners and the losers. They see us having tons of incumbency biases. The winners are always stable. It's not a fair game. And they also see breakdown in civility norms, that is like actual violence, threats of violence. And we saw all of those in these cases, right? And those things, I mean, if you think about what law is and what law is for, law is about, the rule of law is defined by proportionality, the absence of violence, right? And about promoting civil society, kind of civil society. So one of the things they're describing here is that intellectual property's anti-progress characteristics are undermining the rule of law. So let me give you some examples. So one of the things that I'll read it to you, but one of the things that I've always been enamored by a lot of my interviewees is that they have much more tolerance for the kind of infringement that intellectual property is going to be enforced to consider bad. It's like what I was saying at the beginning, we're all tyrants, but we're all okay with that. What does that mean? What they describe it as a form of generosity and a form of cumulative innovation. So this is a singer-songwriter, so the total copy, not so great as market replacement, but someone just taking parts, being influenced by my song, that's totally great, or inspired. It's all this big pool, this idea of a big pool. We're throwing stuff into it, so if someone is being inspired to write something by it or stealing an image, that's unavoidable. So everyday creators seek to do their work and enable others to do their work as well. And the benchmark for them is a kind of a mutual flourishing, not a winner take all. What they're thinking about, I think, many of the time, is that there's an expectation that the public domain is actually much bigger than what the intellectual property system has created over the 20th century. So they think a software programmer would consider it malpractice to create a program from scratch. That's not what we do. If there's a perfectly good set of algorithms laying around to use, it's tried, it's proven, we know this thing is bug-free. So borrowing and sharing, or just taking to make the better software program, that is what software programs do. That's the Google versus Oracle part. So they explain that copying and borrowing is essential to the work, and that this public domain is richer. And therefore, overly aggressive, they consider overly aggressive threats of intellectual property really bothers them. They sound violent and uncivil. So this was typical in many of the interviews. In companies I work for, we file these patents, we're pretty cynical about it. We don't think they're really going to do very much, except in this whole morass that's people wagging sticks at each other saying, I'm going to sue you over your patents. So patents as weapons was a theme throughout the interviews. They also got even more violent. That is, they talk about how patent litigation is a kind of shakedown, beginning with unsophisticated companies. There's your incumbent biases. Without a lot of litigation experience, and plaintiffs identify the weak links in the chain and go after them. We even saw language about having a bigger stick who withstands squeezing, survives, and language about coerciveness, hostage taking, feudal lords, and rapaciousness among copyright owners. This is all about a system that is profoundly dysfunctional. Right? That's what this is about. I think these harms may sound individualized. We tend to think about them as like criminal kind of things, but they're not. This is about a systemic dysfunction and a breakdown in the organizational integrity, I think, of intellectual property law. It's about precarity and their feeling of precarity in a system that's not working for them. And I think it describes for them what's wrong with IP today. One of the things they talk about is how IP system doesn't make good stuff anymore. It creates plaque in the arteries, harder to make good stuff when the system is so clogged up. We have a lot of bad patents, so that's the question about patent reform. And it doesn't actually produce original work. We have many, many more remakes rather than indie films, for example. So it's not producing the kind of originality and innovation that we think. So it's not actually serving its original goals. And what do they say it's doing? It's actually doing, it's wasteful, producing waste. So that's the story of more. Like too much IP is actually thwarting its system. Okay, so I think there is, the last chapter of the book is about institutional resilience. It's about what kind of institutions and organizations of creators and innovators are actually promoting the kind of progress they think, and for them, inclusive and sustainable institutions where creators and innovators can work. So this would be a labor equity argument as well, is what they are seeking. They are not seeking for individual remuneration as much as they are trying to create a community, an institution in which they can mutually flourish. That's the last chapter. All right. So all this has me rethinking progress. Like if we think about law as a living system and law reflecting its practice in everyday life, IP law is being infused with many more values than market values and competition values, and it's being promoted by equality, or at least it's being talked about in those terms: privacy, equality, distributive justice, and inclusive and resilient institutions. And so what that does is it makes people, especially the economists, very allergic to the idea that intellectual property is being infused with moral narratives. But all stories of law are moral narratives. And I think we shouldn't be afraid of that. We should embrace them and we should debate them on their own terms. So there are going to be a debate about there's getting a consensus around which morals are more important. It's going to be hard, but we should at least be arguing about that. We shouldn't outsource our morals to markets. It also questions whether the rule of law is under stress today, which I think we all know that it is, and I think we're seeing that in intellectual property. I think if you think about IP, law's purpose to preserve certain fundamental values like democracy, inclusivity, equality, privacy, fairness, lack of violence, transparency, accountability, proportionality. These are all things that intellectual property is failing to do, at least by the people it's supposed to serve. And so then I think it helps us rethink what kind of progressive values IP should serve in the future, especially, I think, especially given the sense that all of it, we are all interconnected because of the internet, and that we have this shared fate, right? We, like the monkeys, right, have to live on this planet. And so I think intellectual property law is actually debating that exact thing today, which is uncomfortable for IP lawyers and scholars, but I actually think it's undebatable. All right, 20 minutes for questions. I'm really looking forward to your thoughts and questions. Anything is on the table? Anything? Almost. Yeah.
Hi, thanks for being here. I would love to hear sort of more of your thoughts on the causality of this story that you're telling, because I take your point that the internet is sort of this copying machine that has sort of created this mad scramble to increase the IP that firms own. But I'm curious, like, to what extent is this a story about wealth inequality creating a rush to gain more IP versus IP producing more wealth inequality? I would be
exogenous. Yeah. So I'm not making a causal problem at all. A causal story. I cannot. Qualitative work doesn't actually lend itself to causal analysis. But I am suggesting that certain technologies, I mean, you see this in intellectual property case, as well as labor, any area of society, new technologies start challenging old ways of living, and sometimes in giant ways and sometimes in little ways, right? And so I see the internet as or the virality of sharing and the expectation of sharing, the way the generation that has grown up only with the internet expects certain ways and gets annoyed when you can't do those things. So jailbreaking used to be a thing in the late aughts, and now it's not a thing anymore, right? So but jailbreaking was the response to, you tell me I can't open my phone, I can open my phone. And now there's just ways that no, you can't open your phone, right? And warranty, I mean, they fixed it so you can't open your phone, or if you do, it won't work anymore. So and all this is to say that I think that new technologies challenge expectations and I mean, I'm uniquely, lately anyway, self-conscious of the fact that I'm middle-aged, and so I don't know which generation I belong to anymore. Like, I don't relate to my students as well as I used to. Like, literally, like, we don't have the same cultural references anymore. But I think that proves a point, which is the expectations of what you can do with your things today is completely changed. And the internet is part of that. And IP laws are antique. 1946, 1976, and 1952. Like, that's the last time. I mean, so we had the patent statute in 2006, but right, that wasn't a big deal. We have not adopted reform IP laws. We're struggling to do that right now. And so I think the expectations of what one can do today, they're not causal. It's just creating all this tension that is forcing us to challenge fundamental ways of being. And it comes out as wealth inequality. It comes out as gender freedom. I mean, it comes out in a lot of different ways, but those kind of tensions, I think, are productive. That's a lot. It's much more of a descriptive analysis than it is. It's not at all possible. Yeah.
So given the Supreme Court's probably bound to be skeptical or cynical of certain sort of progressive approaches to IP, I wonder how you think, obviously you're telling a descriptive story here, but I wonder how you think the incentive set by the Supreme Court will maybe change or modify the kind of general.
Yeah. So I actually think the Supreme Court is not lenient about certain ways to interpret the Constitution in certain spaces, but I actually think they are quote unquote progressive when it comes to IP for certain reasons. I'm just going to give you some examples. So the Bowman case is a terrible. I give you Bowman case is a terrible example of them not being progressive at all, thinking in terms of distributive justice. But the Warhol case that was just decided last year was pitched as a David and Goliath story. This poor photographer and the Andy Warhol Foundation that was making all this money using her stuff. And that case, am I allowed to swear? Like it's doctrinally a complete mess. I'm not necessarily it came out the wrong way in its result, but it makes no sense. I literally don't know how to teach. I've been teaching copyright law for as long as I've been teaching common law. And so what I think the David and Goliath framing confused them, and we see all of this weird drafting in the decision. So I think it's actually creating bad law, but not anti-progressive. I mean, I don't know if that's an anti-progressive case or not. I haven't decided yet. But there's another case coming up in front of the Supreme Court. I mean, like there are trademark cases most recently. We're all pro free speech. They're striking down bans in the Trademark Act that prevented registering derogatory marks, for example. So the ban, the slants, was an Asian band that they wanted to call themselves slants, and they wanted to register the trademark, and the trademark office said no, because that's derogatory, and we have a ban against derogatory words. And the court said, that's viewpoint discrimination, out. Now, one could think, like, that's inclusive. Like, now this band is renaming themselves, recapturing the word for their own use and infusing it with a positive meaning. And that's good. Like, so what is progressive in IP? Like, part of it is hard to know. And I also just want to say, I think there's an anti-tech bias at the Supreme Court. So there is a traditional, more conservative, with a small c, like big tech is the monopolies of big tech, and I think a lot of the court members are very skeptical of that and of the monopolies. So I think if we're looking for any inroads into how to work these systems, I think the pairing of antitrust and IP, we're going to see that at the Supreme Court. But I don't think it's easy to see at the Supreme Court them they're what we think of as traditional conservative values infusing their IP, and that's what makes them interesting. But it also, as a person who cares about that kind of clarity, it really gives you. Yeah.
I have a question about what you were saying about claims that might be more fraud or about privacy being then brought in the language of IP. And I was wondering if you'd say more about why you think that's happening, and what the implications are. Does it mean that we're losing out on good claims or not attending to other important debates because we're so focused on IP?
So this is an example of what I think of the balloon squeezing metaphor. So the copyright claims that are trying to allege privacy, like Garcia, they're losing because they're not good copyright claims. And you have these doctrinal purists on the courts. They're like, that's not copyright, and we're sticking to right. So although Hill versus Public Advocates, that was just because of the way litigation works, that the plaintiffs won in that case. But when I say balloon squeezing, I think you're losing on the copyright, what's putting a lot of pressure on privacy. We have all this state-based and some federal regulation about privacy. We're actually seeing a lot of reform around privacy law. So it may be that we're going to see less copyright claims dealing with privacy over time because it's being taken care of in these other regulatory arenas. Now, I am not a privacy scholar. I have very good friends who are telling me that those laws are not good enough, for example. But like I do see that kind of thing pressure. Like, so I do think maybe antitrust litigation is going to go up, and we'll see some pressure taking off IP as well. Maybe we'll see that. But I don't see copyright being fixed in that way, precisely because of the First Amendment. Our First Amendment jurisprudence is just too overwhelmingly strong, and it's not getting any less strong. And that cuts into did you ever get it?
Yes, I did. Thank you. I really enjoyed the talk. My question, I'm kind of getting hung up on the Monsanto case.
Yeah.
And I'm wondering, like because your whole argument is an argument about the internet, and that's clearly not about the internet.
It's about self-generating technology.
Okay.
So a seed makes a copy of itself by its own use.
Yeah.
A computer makes a copy of its programs by its own use.
Yeah.
Machine learning technology is all going to be about making stuff without human input at all. And the question is, who's going to be liable for the stuff that's made when it was made to do that, but no human is pushing the button. And that's what I'm talking about. And the court's decision in Monsanto
So most of your examples are from the United States and the Supreme Court. But the internet is global. It
Yeah.
doesn't have a single jurisdiction.
Yeah,
So how does IP
yeah.
globally get parsed?
Well, there's I think it's called the Brussels Doctrine, the idea that, the highest, not, the highest or the lowest threshold is gonna set the standard. And so one of the arguments being made now is that internet and IP policy in Europe, especially internet policy and privacy policy, because all companies work globally, are gonna be setting the standard internationally, whether or not the United States wants to get on board with it or not. Companies are it's gonna be about private ordering rather than federal adherence to federal law. The problem with that is going to be certain laws or amendments, for example, that cut through federal statutes and are gonna make it hard for an entity to do business in both places consistently. That's just not gonna happen. So I agree that the internet is, this is a book about, when I was in Europe most recently talking about it, I was uniquely self-conscious that this is an American, US centrist perspective, but it created very interesting conversations with many people from France and England and Italy who had very different ideas of moral rights, for example, in copyright or patent exemptions, for example, for research tools. And so the question of harmonization came up a lot, but the harmonization is not because we share the same values. The harmonization was for business purposes. And so the Declaration of Human Rights versus the UN, there was a lot of conversation about how we can extract this up to a human rights level and whether that was all possible. So I think your question is absolutely right, but I'm just admitting that this is just US centric. And I think it just means that it's putting pressure in lots of different ways for different treaty negotiations. We're seeing different treaty negotiations for certain aspects of trips. Yeah.
Thank you very much. It's extremely illuminating. And it covers lots of things that I've not particularly thought about. But one thing I've been thinking a lot about is the litigation against GitHub.
Yeah.
And so my question is sort of twofold. On the one hand, that's all about using copyright materials for the purposes of training an AI. So this would be and so this is on behalf of people who feel they should be negotiated with the use of this stuff.
Yeah.
If I'm correctly diminishing it into two.
Right, they put their stuff into GitHub for certain purposes, not for others, and now it's being taken out either contrary to the license or contrary.
But there's left and there's also propagating throughout the whole realm of creative work.
Yeah.
So there are many follow-on suits.
Yeah. Yeah.
So that's one piece. But your assertion that there's no offer when an AI is used.
Well, if there's no human involved. That's, you're asking my position or what the copyright office said, yeah.
All right, well,
Yeah.
in my thinking,
Yeah.
an AI is finally a tool.
Yeah.
It's used.
Right.
So there is either a company or an individual person who would use it. And why not make them liable?
Right, the user. Just like the users of Napster and Grokster were liable, not the maker of the tool.
The user of the tool.
Right. So we had these debates. If you're standing in front of a photocopy machine, you're making a copy, you could be liable. The question of whether the machine is liable or the person who made the machine is liable was this question of secondary liability. Right? And so this debate about prime direct and secondary liability is now going to happen all the time. But AI and machine learning tools is supposed to distance itself from the user and the machine. The whole idea that's supposed to be special about AI, and I'm not an expert, is that it works without humans.
Well, the problem is that we're dealing with an ideology in addition to an actual thing.
Yeah, right.
So,
Right. So
I could say I have my attitude about that.
Yeah.
You could say I have different attitude about that. This is
Yeah.
the humanistic problem of how do we divide the universe.
yeah, so I have been thinking about the AI suits since they've been filed and speaking about them and talking to people about them. And it just put them in the context of the talk that I just gave. The arguments from the plaintiffs on all these AI generated is that we are not being paid for our contributions, that labor value, that there's huge companies that are making tons of money off our stuff and we're not getting anything. That is just, that's the same old story. That's the same old story, right? How we fix and how we pay artists, like how we remunerate artists and innovators for the work they do, whether intellectual property is the right way to do that, you know, I'm skeptical. Like, I think intellectual property is an industrial tool for corporations largely. It has always been for aggregators, rarely for individuals. And the idea that AI should be, I mean, that IP should be the way that authors make money, like, you know, I think it's a problem with the hammer. That everything looks like a nail when you're working with a hammer. Everything looks like an IP problem when you're working with creativity. I think this is just this is not just. This is a problem of how, if we want to support human beings in their creation of work. If we think creativity and innovation is important to human thriving and civilization, for whatever reason, we could ask the question, like, why is it important that people are creative or innovative? We could ask that question. But if we assume that, then we should support the people who do it. Whether we do that through IP or not, I think is a different question. But the IP arguments made in all these cases, I think, are going to miss the mark because you can't pay hundreds of millions and billions of, I mean, the way the internet works is scraping all the data. You just can't do that. That's just not the way it's going to work. And we get a lot of good things from scraping all that stuff. We get Google search. So when authors want to be found on Google search, they don't mind scraping to be found, but they don't want to be scraped to be included in a data set, then we have a question. Well, copyright applies to the same to both, actually. And so copyright's not going to work unless we change copyright. Or we figure out a way to pay you for your work in another way. So UBI, grants, taxes, like I can think of 1,000 ways we can pay people for their work that is better than intellectual property. So as an IP lawyer, I wonder whether like there is a future, but you know, there is. It's just you know, when I get clients who come to me as filmmakers or writers or artists, and they start giving up their copyright, like my copyright. Really, what you want is a decent salary. That's what you want, and you're not to be ripped off. That's another thing you don't want. You know, copyright might help you with that, but it's not. All right, thank you very much. I got to.